questions about the case.
Where is the murder weapon? The clothes you wore that night? What were Kaylee's last words?
She also berated him to his face.
The truth is, you're as dumb as they come. Stupid, clumsy, slow, sloppy, weak, dirty. If you hadn't attacked them in their sleep, in the middle of the night, like a pedophile, Kaylee would have kicked your ass.
Of that sheath that police said they found next to Maddie Mogan's leg in her bed. Police say DNA testing of swabs taken from the sheath revealed a single source of male DNA that didn't come back to anyone when it was put into CODIS, the Combined DNA Index System. CODIS is the FBI's database of known felons. From there, the DNA sample was sent to Othram Labs in Texas, and they got to work performing genetic genealogy work to put a name with the DNA sample. The FBI, of course, took over that work in December, and by December 19th, they'd given the name Bryan Kohberger to Moscow police.
There is a version of this story where Bryan Kohberger walks free. He was a PhD student in criminal justice. He had spent years studying how investigators catch killers. He understood DNA evidence, how touch transfer works, how samples get contaminated, how defense attorneys challenge collection protocols. He understood cell phone location data and how long carriers retain it. He understood surveillance camera networks and license plate recognition systems. He had read the academic literature on forensic countermeasures, what offenders do wrong, and how investigators respond. Bryan Kohberger did not walk into 1122 King Road as an impulsive offender. He planned this, methodically. And then he walked in anyway. What followed was 47 days of federal investigation, 3 near collapses of the prosecution's case, one of the most consequential uses of forensic genetic genealogy in American criminal history, and 17 specific failures on Kohberger's part, each individually survivable. Collectively, they were not. I've spent weeks reviewing the probable cause affidavit, the court filings, the DNA legal challenge, the CSLI records analysis, and the complete evidentiary record of every major development in this case. What I'm going to give you is not a retelling. It is a structured forensic analysis, the evidence, the investigative decisions behind it, and the precise moments where this case almost went a fundamentally different direction. Because that other version, the one where he walks free, I want you to understand exactly how close it came to being real. Let's go. Moscow, Idaho has a population of approximately 25,000 people. It is a college town built around the University of Idaho, where the violent crime rate is low enough that major criminal investigations are rare events in the department's institutional history. The city sits in the northern panhandle of Idaho, just 8 miles from the Washington state border. It's the kind of place where people don't lock their doors, where students walk home alone at night without concern, where the most serious crimes police typically respond to involve property theft or minor drug offenses. The University of Idaho dominates the landscape, physically, economically, and culturally. The campus employs thousands of people. The student body makes up nearly half the town's population during the academic year. 1122 King Road was a 3-story, 6-bedroom rental house approximately 3/4 of a mile from campus. The kind of structure you find in every college town, slightly worn, fully occupied, full of the ordinary rhythms of young adults living together. The house sat on a sloped lot, which gave it an unusual structural configuration. What appeared from the front as a 2-story building was actually 3 floors when viewed from the back. 6 people lived there. The house had been divided into individual bedrooms, each rented separately, creating the kind of shared living arrangement common among college students. On the morning of November 13th, 2022, 4 of them were murdered in their beds. Kaylee Gonsalves was 21 years old, a senior majoring in marketing, described by everyone who knew her as fiercely loyal and outgoing. She had accepted a position with a marketing firm in Austin, Texas, set to begin after graduation. She and Madison Mogan had been best friends since childhood. They had grown up together in the same hometown, chosen the same university, lived in the same residence halls as freshmen, and eventually ended up sharing a bedroom on the top floor of King Road. Madison Mogen was also 21, also majoring in marketing, also a senior preparing for graduation. Known for her humor, her warmth, her closeness to her family, and an unwavering loyalty to the people in her life. Madison and Kaylee weren't just roommates or college friends. They were sisters in everything but blood. Zana Kernodle was 20 years old, a junior majoring in marketing with a minor in information technology. She was known for her kindness, her smile, and her dedication to both her studies and her relationship with a boyfriend. Ethan Chapin was also 20, a freshman studying recreation management, one of a set of identical triplets. He had no permanent room at King Road. He was there because he was with Zana. All four were killed with a fixed-blade knife. The medical examiner estimated time of death between approximately 3 and 4 a.m. on November 13, 2022. The autopsy reports indicated that the victims suffered multiple stab wounds. Some victims showed defensive wounds, evidence that they had attempted to fight back. The force and nature of the injuries suggested someone physically strong, someone who attacked with determination and violence. The two surviving roommates, Bethany Funk and Dylan Mortensen, were on the first floor. Their rooms were below the floors where the attacks occurred. Neither reported hearing sounds that they recognized at the time as a violent assault 2 floors above them. At some point during the early morning hours, Dylan Mortensen opened her bedroom door. She later told investigators she saw a figure in the hallway, male, approximately 5 feet 10 inches tall, dark, bushy eyebrows, a mask covering the lower portion of his face, black clothing. The figure walked past her toward the sliding glass door at the back of the house. According to the probable cause affidavit, Mortensen described the individual as walking with purpose, moving quickly and deliberately toward the exit. The individual did not speak, did not acknowledge her beyond a brief moment of eye contact, did not deviate from his path toward the door. He looked at her briefly, then he walked past her toward the sliding glass door at the back of the house. The door opened. He left. Mortensen went back into her bedroom and locked the door. She did not immediately call 911. She did not wake Bethany Funk. She did not go upstairs to check on her roommates. The clinical literature on threat-induced freeze response is extensive and consistent. Her inability to act immediately is a documented and well-understood neurological response to extreme threat. It tells us nothing about her reliability as a witness. It tells us everything about what a human brain does when it cannot process what it is seeing. When a person is confronted with a threat, their brain cannot immediately categorize or respond to. The autonomic nervous system initiates what neuroscientists call tonic immobility, a state characterized by muscle rigidity, vocal suppression, and an inability to initiate defensive action. This is not a choice. This is not cowardice. This is a neurobiological response that occurs below the level of conscious control. In Mortensen's case, what she was seeing, a masked stranger walking through her house in the middle of the night, was so far outside her frame of reference, so incompatible with the safe environment she believed she was living in, that her brain essentially locked up. She retreated to a room, locked the door, and remained there until morning. But it meant that 8 hours passed between the murders and the 911 call. That call did not come from either surviving roommate. It came from a friend who arrived at the house around noon on November 13th after hours of unanswered calls and texts to the residents. When police arrived, 4 bodies. Significant blood evidence across 2 floors. 1 K-bar knife sheath found under the body of a victim on the 2nd floor. The knife itself absent. No identifiable fingerprint record on any surface that could immediately point to a suspect. No murder weapon. No known motive. No clear suspect. The Moscow Police Department had never investigated a quadruple homicide. Within hours, the Idaho State Police were involved. Within 24 hours, the FBI had deployed resources. Within 48 hours, a multi-agency task force was in place, and the largest criminal investigation in Idaho history was underway. That is the scene. That is where this investigation begins. For the first 2 weeks after the murders, law enforcement said almost nothing publicly. Press conferences were held, but they offered little in the way of substantive updates. Police spokespeople repeated the same reassurances. Investigators are working around the clock. All available resources are being deployed. There is no immediate threat to the community. When pressed for details, suspects, motive, murder weapon, timeline, officials deflected or declined to comment. To the public, to the media, to the families of the victims, it looked like failure. The University of Idaho community was terrified. Students were leaving campus, returning home to their families despite the semester not yet being over. Parents were pulling their children out of school. National media had descended on Moscow and were getting nothing. Local officials were being asked questions they couldn't answer. Vigils were being held. Memorials were growing on campus. And still, no arrest. No named suspect. The silence looked, from the outside, like an investigation without leads. The silence was deliberate. It was the correct operational call. The decision to limit public information during the first weeks of the investigation was not a failure of communication. It was a strategic choice, rooted in sound investigative practice. When law enforcement is building a case against an unidentified suspect, particularly a suspect who may be forensically sophisticated, every piece of information released to the public is also information delivered to the suspect. If investigators had publicly stated that they were searching for a white Hyundai Elantra, that information would have reached the suspect within minutes. If they had revealed that DNA evidence had been recovered from the crime scene, the suspect would have known that disposing of additional evidence needed to become an immediate priority. If they had disclosed that they were analyzing cell phone records, surveillance footage, or digital evidence, the suspect would have understood the investigative methods being deployed and adjusted behavior accordingly. Operational security during the investigative phase of a major case is not about hiding failure. It is about protecting the integrity of the evidence and the viability of the ultimate prosecution. Within 48 hours of the murders, the FBI had joined the investigation in force. The Behavioral Analysis Unit was deployed to develop offender profiles and assess behavioral evidence. The evidence response team was processing the crime scene in forensic detail, using methods and technologies that local departments typically do not have routine access to. And investigators had already found something significant. Surveillance footage pulled from the area around King Road, requested from businesses, the university, and residential properties within the first 48 hours, showed a white sedan in the area at approximately 4:04 a.m. on November 13, 2022. The vehicle appeared on camera multiple times, moving through the neighborhood, circling the area in a pattern that suggested someone either lost or deliberately surveilling a location. A second camera, positioned approximately a mile away on one of the main routes out of Moscow, captured what appeared to be the same vehicle moving away from the area at approximately 4:20 a.m. Investigators noted the timeline. The vehicle appeared in the area shortly after the estimated time of the murders, then departed approximately 16 minutes later. Forensic video analysts were brought in to enhance the footage, clarify the make and model of the vehicle, and attempt to identify any distinguishing characteristics. The vehicle was later confirmed as a 2011 to 2013 Hyundai Elantra, white in color. No license plate was clearly visible in the available footage, which eliminated the fastest route to identification. This is mistake number one. Bryan Kohberger drove to and from 1122 King Road on streets covered by surveillance cameras. He had apparently planned his approach to avoid major intersections with known camera infrastructure. College students in the area would know where these cameras were. Someone with Kohberger's educational background would have understood the necessity of avoiding them, but he had not accounted for the full density of the secondary network. The business cameras monitoring parking lots, the university cameras positioned at building entrances, the residential cameras installed by homeowners. Moscow, Idaho is a small town, but it is a college town in 2022, and that means cameras are everywhere. Investigators methodically requested footage from every property within a defined radius of King Road. They built a comprehensive map of vehicular traffic moving through the area during the relevant time window. Kohberger was visible from multiple angles on the night he committed 4 murders. Investigators issued a public bulletin requesting information about a white Hyundai Elantra. This generated approximately 22,000 tips. The Hyundai Elantra is one of the most common economy sedans on American roads. Whether Kohberger chose it deliberately for its anonymity or simply owned it because it was an affordable, reliable vehicle is not established in the public record. What is established is that its commonality created a significant signal-to-noise problem. 22,000 tips is an unmanageable volume using traditional investigative methods. Each tip would need to be reviewed, assessed, and either followed up on or cleared. Even with a large task force that represents thousands of hours of investigative labor, most of which would lead nowhere. This is mistake number 2. The vehicle was common enough to generate 22,000 tips, but modern license plate recognition technology processes volume without difficulty. Idaho State Police ran LPR data from across the region against the murder window. License plate recognition systems, deployed by municipalities, state police agencies, and increasingly by private companies operating vehicles equipped with mobile LPR cameras, capture and store millions of plate images daily. Each image is time-stamped and geotagged. Investigators queried every available LPR database for white Hyundai Elantras captured on any camera within a defined geographic radius during the relevant time window. The search was not limited to Moscow. It included surrounding towns, highway corridors, and border crossings into Washington. Bryan Kohberger's 2015 white Hyundai Elantra, Washington state plate, was captured by a plate reader on State Route 95, approximately 10 miles south of Moscow, at 4:48 a.m. on November 13, 2022. That plate led to the registered owner. The registered owner led to an address in Pullman, Washington. The address led to Washington State University. Washington State University led to a criminology PhD student named Bryan Christopher Kohberger. Within 72 hours of the murders, investigators had a named person of interest. They had his vehicle. They had his address. They had his academic and employment history. And they knew they could not move on him until they had more. The investigation split immediately into 2 parallel tracks: build physical evidence sufficient for a search warrant and arrest, and gather intelligence covertly without alerting Kohberger to the investigation. Both tracks were essential. Both nearly failed. As investigators built a case, they were simultaneously conducting non-invasive surveillance of Kohberger's movements and communications. Surveillance at this stage is delicate. Kohberger was not under arrest. He had not been charged with a crime. He was, in the eyes of the law, a private citizen entitled to the full protections of the Fourth Amendment. The legal framework for surveilling a private individual not yet under arrest requires precision. Law enforcement can observe behavior that occurs in public spaces without a warrant. They can follow a vehicle on public roads. They can collect information from publicly available sources. But any investigative activity that intrudes into spaces where an individual has a reasonable expectation of privacy, inside a home, inside a vehicle, communications that are not broadcast publicly, requires judicial authorization. The line between lawful surveillance and unlawful search is not always clear, and any misstep creates suppression exposure. Evidence obtained in violation of the Fourth Amendment cannot be presented at trial. If investigators had deployed investigative techniques that exceeded their legal authority, electronic surveillance without a warrant, physical intrusion into Kohberger's residence or vehicle, interception of communications, the defense would have moved to suppress any evidence obtained as a result, and any evidence derived from that initial unlawful search would also be excluded under the doctrine known as fruit of the poisonous tree. In other high-profile cases, overreach during the pre-arrest surveillance phase has created evidentiary problems that prosecutors struggled to manage all the way through trial. The investigation team here navigated this correctly, but the risk was real and constant. The use of forensic genetic genealogy to identify Kohberger was a constitutional argument with genuine merit, and it came within a single judicial ruling of destroying the most critical piece of forensic evidence in the case. The defense mounted a sophisticated legal challenge, arguing that the use of third-party genetic databases to identify criminal suspects violated the Fourth Amendment rights of the individuals whose DNA had been used to build the family tree that led to Kohberger. Had that challenge succeeded, the DNA evidence would have been excluded. The case would have proceeded without it. Dylan Mortenson's description of the figure in the hallway, dark, bushy eyebrows, mask covering the lower face, black clothing, approximately 5 feet 10, was consistent with Kohberger's physical appearance and became a significant piece of the prosecution's identification narrative. But the 8-hour delay between the murders and the 911 call, and the extended period during which the crime scene remained accessible to the surviving occupants, gave the defense a sustained line of attack on the evidentiary weight of her account. Defense counsel challenged the reliability of Mortenson's account in pre-trial proceedings, arguing that the timeline created legitimate questions about what she had seen, when she had seen it, whether her perception had been accurate in a moment of extreme stress, and whether her recollection had been shaped by subsequent exposure to information about the case. Memory science supports some of these concerns. Eyewitness testimony, even from individuals who genuinely believe they are providing accurate accounts, is subject to distortion over time. Exposure to media coverage, conversations with investigators, and the process of repeatedly recounting an event can all alter the content and confidence of a witness's memory. Prosecutors held. The account survived pre-trial challenge and remained part of the evidentiary record. But the vulnerability was real, and it persisted as a pressure point for the defense throughout the pre-trial process. The DNA evidence in the Bryan Kohberger case is what most people believe they understand. It is also the piece most consistently misrepresented in public coverage of this case. Here is what the forensic record actually shows. During the forensic processing of 1122 King Road, investigators found a K-bar knife sheath. A K-bar is a fixed-blade tactical knife, military-grade, commercially available through retail channels, military surplus stores, and online vendors. The design is iconic. A 7-inch carbon steel blade, a handle designed for secure grip, and a leather sheath designed to protect the blade and allow the knife to be carried on a belt or tactical vest. The sheath was found under the body of Madison Mogan on the 3rd floor of the residence. It was located during the methodical processing of the crime scene by the FBI Evidence Response Team, which treated the entire house as a controlled forensic environment, documenting every item, surface, and biological deposit according to federal evidence handling protocols. 2 things about the sheath are forensically critical. First, the sheath was there. The knife was not. Whether the knife detached from the sheath during the attack was deliberately removed and taken from the scene or was lost in the chaos of the assault is not established with certainty in the public record. What is clear is that the knife itself, the murder weapon, has never been recovered. Extensive searches of the area, including the route Kohberger would have taken returning to Pullman, have not located it. The absence of the knife eliminated one class of potential physical evidence: blade type, edge geometry, manufacturer-specific markings, potential biological evidence on the handle or blade that would otherwise have been available to investigators. But the presence of the sheath introduced another. Second, the sheath contained biological material. Specifically, analysts identified what forensic scientists call touch DNA. Touch DNA is the microscopic biological material transferred from human skin cells to any surface a person physically contacts. It is not blood, it is not saliva, it is not a conventional DNA sample obtained from a clearly identified biological deposit, like semen or tissue. It is trace material, small in quantity, sometimes degraded, and subject to methodological debate that has existed in the forensic science community for over a decade. Touch DNA is transferred whenever a person touches an object. Skin cells are constantly shedding from the human body, thousands of cells per hour. When you pick up a phone, open a door, grip a steering wheel, or handle any object, you deposit a microscopic layer of your biological material on that surface. In ideal conditions, touch DNA can be collected, amplified using polymerase chain reaction techniques, and analyzed to produce a full DNA profile suitable for comparison. But touch DNA is also vulnerable to contamination, degradation, and secondary transfer. Secondary transfer is the key risk. Biological material can move from surface to surface in ways that place a person's DNA at a location they never physically occupied. If person A shakes hands with person B, and person B then handles an object, person A's DNA may be transferred to that object even though person A never touched it. Defense teams in touch DNA cases routinely exploit this uncertainty, and they have done so successfully in multiple high-profile cases. The forensic science community has not reached consensus on touch DNA's absolute reliability as a standalone evidentiary basis for conviction. Some experts argue that touch DNA, particularly when found in low quantities or mixed with other individuals' DNA, should be treated as investigative evidence rather than definitive proof of physical presence. Others maintain that with proper collection and analysis protocols, touch DNA is as reliable as any other form of biological evidence. The FBI laboratory analyzed the biological material found on the snap mechanism of the sheath, the metal button closure that secures the sheath around the knife. This is a surface that would be directly contacted by anyone handling the sheath to insert or remove the knife. A full male DNA profile was successfully developed and confirmed. The profile was of sufficient quality and completeness to be suitable for database comparison. That profile was submitted to CODIS, the Combined DNA Index System, the federal database containing approximately 21 million criminal DNA profiles from individuals convicted of qualifying offenses or arrested for certain crimes in jurisdictions that allow arrestee DNA collection. No match. Bryan Kohberger had no prior felony record. His DNA was not in the system. He had never been arrested for an offense that would have required DNA submission. He was, from CODIS's perspective, invisible. This is mistake number 3. Kohberger left the sheath. This single physical artifact, a byproduct of the knife somehow becoming separated from its sheath at some point during the attack, contained the biological material that would anchor the entire prosecution's case against him. Had he taken the sheath when he left the scene, the most critical forensic evidence in this case would not exist. In a pre-2018 investigative environment, this is where the DNA evidence reaches a dead end. A developed profile with no CODIS match and no identified suspect is a forensic artifact, significant to retain and protect for potential future comparison, but not immediately actionable without a suspect to compare it against. The crime scene DNA profile from the knife sheath was uploaded to a genetic genealogy database. The database search returned partial matches, individuals who shared measurable amounts of DNA with the unknown male whose biological material had been found on the sheath. Because DNA is inherited, biological relatives share predictable amounts of genetic material. Parent and child share approximately 50%, siblings share approximately 50%, first cousins share approximately 12.5%. The further the biological relationship, the smaller the shared percentage. But even distant relatives, third cousins, fourth cousins, share detectable amounts of DNA that can be identified through database comparison. The genealogy search in this case returned partial matches consistent with a male subject with family roots in the northeastern United States, born between approximately 1980 and 2005. Professional genealogists worked with investigators to build family trees from those partial matches, applying traditional genealogical research methods to narrow the field. The research pointed toward the Kohberger family in Pennsylvania. At this point, investigators had a potential family connection. They had a named individual, Bryan Kohberger, who fit the age range, the physical description from the surviving witness, the geographic profile suggested by the vehicle data, and the educational background that might explain the methodical planning evident in the offense. But they did not have a confirmed DNA match. They needed a direct biological sample from Bryan Kohberger to compare against the crime scene profile. Investigators in Pennsylvania conducted what the law enforcement community calls surreptitious DNA collection. Kohberger's father had placed garbage at the curb outside the family residence for municipal collection. Under settled American law, established through decades of Fourth Amendment jurisprudence, garbage placed for collection at a public curb is considered abandoned property. The individual who discarded it has relinquished any reasonable expectation of privacy in its contents. The Fourth Amendment does not require a warrant to collect and analyze abandoned property. A sample was obtained from the discarded material and submitted to the FBI laboratory for analysis. The forensic question was specific. Is the crime scene DNA profile consistent with being the biological son of the male whose DNA was collected from the garbage? The result? The crime scene DNA profile was consistent with being the biological son of the male whose DNA was collected from the Pennsylvania garbage. This is not a direct match. This is a statistical probability statement based on the inheritance patterns of genetic material. But the statistical probability was high enough, consistent with a parent-child biological relationship, to provide probable cause. Investigators had enough. They drafted an arrest warrant and a search warrant. On December 30th, 2022, 47 days after the murders, Bryan Kohberger was arrested at his family's home in Pennsylvania. And then the defense filed a motion that threatened to unravel everything. Following Kohberger's arrest, his defense team filed motions challenging the use of investigative genetic genealogy as a violation of the Fourth Amendment's prohibition on unreasonable searches and seizures. Individuals who submitted DNA to GEDmatch did so for ancestry and health purposes, not law enforcement. At the time many submitted their profiles, GEDmatch's terms of service did not clearly communicate that their genetic data could be accessed by law enforcement to identify criminal suspects who were not themselves database participants. Users had a reasonable expectation that their genetic information would be used for the purposes they intended, genealogy and health research, and not for purposes they had not consented to. The defense argued that using this data to build a family tree that led to Bryan Kohberger constituted a warrantless genetic search of millions of individuals who had not meaningfully consented. Each of those individuals had a Fourth Amendment right to be free from unreasonable government searches. The government had conducted a search of their genetic data, one of the most personal and revealing forms of information a person can possess, without a warrant, without probable cause, and without the knowledge or consent of the individuals whose data was being searched. This was not a hypothetical concern. Constitutional law scholars had been raising precisely these questions since the Golden State Killer identification in 2018. Academic journals had published articles questioning whether investigative genetic genealogy violated the Fourth Amendment. Privacy advocates had argued that allowing law enforcement to access consumer genetic databases effectively created a genetic surveillance infrastructure that could be used to track and identify anyone with relatives in the system, which, given the size and growth of these databases, increasingly meant nearly everyone. Federal courts had not definitively ruled on the Fourth Amendment implications of investigative genetic genealogy. The legal ground was genuinely unsettled. Different courts, applying different interpretive frameworks, had reached different conclusions about the constitutionality of similar investigative techniques. The defense argument had merit. A court could reasonably have concluded that the use of third-party genetic data without a warrant violated the Fourth Amendment. Idaho District Judge John Judge reviewed the challenge and issued his ruling. He denied the defense's motion to exclude the DNA evidence. His ruling rested on two core findings. First, GEDmatch's terms of service, updated following the Golden State Killer case and subsequent public controversy over law enforcement access, explicitly permitted law enforcement use of the database under specific conditions. Users who uploaded their DNA data after those terms of service were updated had clear notice that their data could be accessed by law enforcement. Second, the individuals whose partial matches were used to build the family trees that led to Kohberger had consented to law enforcement access through an opt-in setting that GEDmatch had implemented. Users could choose to make their data available for law enforcement use, or they could restrict access to genealogical research only. The individuals whose data was used in this investigation had affirmatively opted in to law enforcement access. The ruling was legally defensible. Judge John Judge applied established Fourth Amendment principles, reasonable expectation of privacy, consent, third-party doctrine, to the specific facts of this case and concluded that the use of the database did not violate the Fourth Amendment. But it was not the only ruling a court could have reached on these facts. A different judge, applying a different interpretive framework to an unsettled constitutional question, could have reached the opposite conclusion. A judge more concerned with genetic privacy could have concluded that the third-party individuals whose DNA was searched had not meaningfully consented to law enforcement access. Even if they had technically opted in under terms of service they likely did not fully read or understand. A judge more skeptical of law enforcement use of consumer databases could have concluded that the government's interest in solving crimes, however compelling, did not outweigh the privacy rights of millions of individuals whose genetic data was being searched without individualized suspicion. If the motion had succeeded, the DNA evidence would have been excluded from trial. The prosecution would have been left with vehicle surveillance footage showing a white Hyundai Elantra in the area at the time of the murders. Cell phone location data showing Kohberger's phone in the area on multiple occasions before the murders and going dark during the murder window. Eyewitness testimony from Dylan Mortensen describing a masked figure in the house, and the subsequent recovery of items from Kohberger's residence consistent with the crime. Strong evidence, compelling evidence, but significantly more vulnerable to reasonable doubt than a direct DNA match to a physical artifact found at the crime scene under the body of a murder victim. The DNA evidence is treated in public discussion as the bedrock of this prosecution. It is presented as the unassailable proof that Bryan Kohberger was physically present in that house, that he handled that sheath, that he committed these murders. It nearly was not admitted at all. This is the moment in the Kohberger case that deserves far more analytical attention than it has received. The use of forensic genetic genealogy in criminal investigations remains legally contested. The Kohberger case will likely not be the last time a court is asked to decide whether this investigative technique violates constitutional rights. And the next judge might rule differently. Every smartphone, regardless of whether it is actively making a call, sending a message, or running any visible application, periodically communicates with the nearest available cell tower. This communication is automatic and continuous. It is how the phone remains connected to the cellular network, ready to receive calls and messages. It is how the phone maintains its ability to access data services, and it generates a record. That record is called cell site location information. The record captures two pieces of information: the time of the communication and the identity of the cell tower the phone connected to. Because each cell tower has a known geographic location and a defined coverage area, this allows investigators to place a device within a geographic radius at a specific point in time. The precision of that geographic radius depends on the density of the cell tower network. In urban areas with high tower density, cell site location information can place a phone within a few hundred meters. In rural areas with sparse tower coverage, the radius may be several miles. The data does not provide GPS-level precision. It does not show exactly where a phone was, but it shows which tower the phone was communicating with, and that is often enough to establish presence in a defined area. Wireless carriers retain this data for varying periods, some for months, some for years, depending on the carrier's data retention policies and regulatory requirements. Law enforcement obtains these records with a court order, not a warrant, because cell site location information is considered business records held by a third party, rather than the content of communications protected by stricter privacy standards. And because modern smartphones ping towers continuously, every few minutes, every hour, throughout the day and night, whether the user is aware of it or not, the resulting records constitute an extraordinarily granular location history. Not a single data point showing where someone was at a specific moment. A map of nearly everywhere they went, across days, weeks, months. Bryan Kohberger's cell site location information records covered the months preceding November 13, 2022. When investigators obtained Kohberger's records through a court order served on his cellular carrier, they found a pattern that the probable cause affidavit describes in precise and damning terms. His phone had pinged cell towers in the immediate area of 1122 King Road on at least 12 separate occasions during the months preceding the murders. 12 visits, 12 nights. Multiple occasions between late August and mid-November 2022. Late night hours, visits occurring at 2 a.m., 3 a.m., 4 a.m. Hours when there is no legitimate reason for a person to be in a residential neighborhood unless they live there, are visiting someone who lives there, or are conducting surveillance. Bryan Kohberger did not live in Moscow. He lived in Pullman, Washington, 8 miles away across the state border. He had no established professional reason to be in Moscow at those hours. He was a PhD student at Washington State University. His academic work, his teaching responsibilities, his research obligations, all were centered in Pullman. He had no documented social connections to the residents of 1122 King Road. Investigators found no evidence that he knew any of the victims, that he had ever communicated with them, that he had any social or professional relationship that would explain repeated visits to the area where they lived. There was no established reason for him to be there, and yet, there he was, 12 times, in the middle of the night. Kohberger was conducting reconnaissance. He was applying the offender behavior framework he had spent years studying in his criminology coursework. Academic literature on pre-offense behavior, particularly in cases involving planned violent crimes, describes a consistent pattern. Offenders engage in location familiarization. They visit the target site multiple times before the offense. They observe patterns of occupancy, who comes and goes, when lights go on and off, when the location is most vulnerable. They assess approach routes and exit routes. They identify potential witnesses, potential obstacles, potential complications. They build a mental map of the environment so that when they commit the offense, they are operating in familiar terrain rather than unknown space. Kohberger was doing exactly what the literature describes: visiting the area, observing the house, learning the rhythms of the neighborhood, preparing. And every time he drove to Moscow and positioned himself near King Road in the middle of the night, his smartphone was transmitting a continuous, time-stamped, carrier-certified record of his location to his cellular provider. Mistakes 4 through 15. 12 individual visits, 12 independent records, each one individually contributing to the prosecution's argument that what occurred on November 13, 2022 was not impulsive, not a spontaneous act of violence, not a random crime. It was premeditated. It was planned. It was prepared over the course of months. Each visit is a separate mistake because each visit was a separate opportunity to recognize the risk. After the first visit, Kohberger could have realized that his phone was generating a location record and turned it off, or left it at home on subsequent visits. After the second, third, or fourth visit, he could have adjusted his behavior. He did not. He kept returning, and he kept bringing his phone. At approximately 2:47 a.m. on November 13, 2022, Bryan Kohberger's phone went into airplane mode. This was a deliberate action. Airplane mode is not something that happens accidentally. It requires the user to access the phone's settings or control panel and manually activate a mode that disables all wireless communications, cellular, Wi-Fi, Bluetooth. It is called airplane mode because it was originally designed to comply with regulations prohibiting the use of devices that transmit radio signals during flight. Kohberger understood, correctly, that a phone in airplane mode does not generate cell site location information records. The cellular radio is disabled. The device stops communicating with towers. From the carrier's perspective, the phone effectively disappears. It is no longer on the network. It is no longer generating location data. The final cell tower ping before the phone went dark placed the device in Pullman, Washington, on a trajectory consistent with travel toward Moscow, Idaho. The phone remained in airplane mode for approximately 2 hours. During that window, between approximately 2:47 a.m. and 4:48 a.m., the forensic evidence indicates that Kohberger drove from Pullman to Moscow, entered 1122 King Road, committed 4 murders, and drove back toward Pullman. At approximately 4:48 a.m., the phone came back online. It immediately pinged a cell tower in Pullman, Washington, 8 miles from Moscow, consistent with Kohberger having returned to the area where he lived. The timing was precisely consistent with the drive time from King Road back to the Washington State University area. Here is the forensic principle that Kohberger either did not understand or significantly underestimated. The absence of data is itself a data point. A 2-hour gap in a carrier's cell site location information record when every other night in that same individual's usage history shows continuous pings throughout the night, is not a neutral fact. It is an anomaly. It is a deviation from established pattern, and anomalies require explanation. When that anomaly coincides precisely with the temporal window of 4 homicides committed 13 miles from where the phone went dark and 8 miles from where it reappeared, the absence of data becomes as incriminating as presence. Kohberger's decision to put his phone in airplane mode demonstrates that he understood the risk of cell site location information tracking. He took a specific, deliberate countermeasure to prevent his phone from generating a location record during the time he was committing the murders. But by doing so in a way that created a conspicuous gap in an otherwise continuous data record, and by failing to account for the 12 prior visits that had already established a pattern of presence near the crime scene, he turned what might have been an effective countermeasure into additional evidence of premeditation and consciousness of guilt. Mistake number 16. The phone going dark is not exculpatory. It is inculpatory. On the morning of November 13, 2022, hours after the murders, Bryan Kohberger's phone pinged cell towers in the area of 1122 King Road again. The cell site location information records show his phone in the area at approximately 9 a.m., roughly 5 hours after the murders, and several hours before the 911 call that would bring police to the scene. Returning to the scene of a crime is a behavior documented extensively in criminal psychology literature. Offenders return for a variety of reasons: to assess whether the crime has been discovered, to retrieve something left behind, to relive the experience, or because of an unconscious psychological compulsion that even the offender may not fully understand. In Kohberger's case, the motive for returning is not definitively established in the public record, but the fact of his return, documented by the same cell tower location data that had documented his 12 prior reconnaissance visits, provided investigators with additional evidence of his connection to the location and additional support for the argument that his presence in the area was not coincidental. Mistake number 17. He went back, and his phone recorded it. Following Kohberger's arrest on December 30, 2022, investigators executed search warrants on his residence in Pullman, Washington, his office at Washington State University, and his vehicle. The physical evidence recovered during those searches has not been fully disclosed in public court filings, but what has been revealed includes several items of significant evidentiary value. Kohberger's 2015 white Hyundai Elantra was seized and subjected to forensic examination. Investigators were looking for biological evidence, blood, hair, fibers, DNA, that might link the vehicle to the crime scene or the victims. According to court filings, the forensic examination of the vehicle did not identify the victim's DNA inside the car. This absence has been cited by defense attorneys as evidence that Kohberger was not the perpetrator, arguing that if he had transported victims, attacked victims in the vehicle, or had significant contact with victims, biological evidence would be present. Prosecutors have countered that the absence of victims' DNA in the vehicle is not exculpatory. The victims were killed inside the residence. There is no allegation that they were transported in Kohberger's vehicle. The crime occurred inside the house. The vehicle was used for transportation to and from the scene, not as a location where the crime itself occurred. However, the forensic examination did identify other evidence. The specific details have not been fully released, but filings reference the recovery of fibers and other trace evidence that may be relevant to the prosecution's case. The search of Kohberger's apartment in Pullman reportedly recovered additional items that investigators believe are relevant, though again, the specific details have been partially sealed to protect the integrity of the ongoing prosecution. What has been confirmed through court filings is that investigators were looking for specific categories of evidence: the murder weapon, clothing consistent with what the surviving witness described, digital devices that might contain searches or communications relevant to the crime, and any other items that might connect Kohberger to the victims or the crime scene. The murder weapon, the K-bar knife, has not been recovered. Extensive searches of the area, including the route between Moscow and Pullman, have not located it. Its absence is a vulnerability in the prosecution's case, but not a fatal one. Cases have been successfully prosecuted without recovery of the murder weapon, particularly when other evidence is strong. Investigators obtained search warrants for Kohberger's digital devices, computers, tablets, smartphones, external storage devices. Digital forensics teams conducted examinations to recover browsing history, search queries, communications, location data, and any other information that might be relevant. Specific findings from those searches have largely been kept under seal, but prosecutors have indicated in court filings that digital evidence will be part of their case at trial. The nature of that evidence, whether it includes searches related to the victims, the crime scene, methods of committing murder, or forensic countermeasures, has not been publicly disclosed. But the fact that prosecutors are retaining digital evidence as part of their trial strategy suggests that what was found is more helpful to the prosecution than the defense. Bryan Kohberger was not a typical criminal defendant. He was a PhD student in the Department of Criminal Justice and Criminology at Washington State University. His academic focus was on the psychology of criminal offenders, the investigative techniques used to apprehend them, and the behavioral patterns that distinguish different categories of offenders. He had completed a master's degree in criminal justice before enrolling in the PhD program. He had written academic papers. He had assisted faculty with research. He had taught undergraduate courses in criminal justice topics. He had spent years immersed in the academic study of how criminals think, how they plan, how they attempt to evade detection, and how investigators catch them. This background creates a unique profile. Kohberger was not someone who committed a crime impulsively, without understanding the consequences. He was someone who understood, in academic and theoretical terms, exactly what investigators would look for, exactly what evidence would be most damaging, and exactly what mistakes most offenders make. And yet, he made those mistakes anyway. Let me summarize the 17 specific, documentable failures that collectively destroyed any possibility of Kohberger evading accountability for these crimes. Mistake number 1. Driving to and from the crime scene on streets covered by surveillance cameras, allowing his vehicle to be captured on video and identified. Mistake number 2. Driving a vehicle common enough to generate 22,000 tips, but distinctive enough to be identified through license plate recognition data. Mistake number 3. Leaving the knife sheath at the crime scene, providing the single most important piece of physical evidence linking him to the murders. Mistakes 4 through 15. Conducting 12 separate reconnaissance visits to the area of the crime scene in the months before the murders, each visit generating a cell tower location record that established a pattern of presence. Mistake number 16. Putting his phone in airplane mode during the time window of the murders, creating a conspicuous gap in his location data that drew investigative attention rather than deflecting it. Mistake number 17. Returning to the area of the crime scene hours after the murders, generating additional cell tower records that further established his connection to the location. Each of these failures was individually survivable. A single piece of evidence, a vehicle sighting, a cell tower ping, even touch DNA on a recovered item can be challenged, explained, or contextualized in ways that create reasonable doubt. But 17 failures, considered collectively, create a web of evidence that is extraordinarily difficult to escape. Each piece of evidence corroborates the others. The vehicle sightings corroborate the cell tower data. The cell tower data corroborates the DNA evidence. The DNA evidence corroborates the eyewitness description. The reconnaissance pattern corroborates premeditation. The gap in the phone data corroborates consciousness of guilt. This is not a case built on a single piece of evidence that must bear the entire weight of the prosecution's theory. This is a case built on multiple independent lines of evidence that all point in the same direction. The central paradox of the Bryan Kohberger case is this. His knowledge should have made him more dangerous, not less. Someone with his academic background should have understood the risks better than almost any other potential offender. He should have known to avoid surveillance cameras. He should have known to leave his phone at home. He should have known not to conduct reconnaissance visits that would create a documented pattern. He should have known not to leave physical evidence at the scene. He should have known that forensic genetic genealogy was a tool investigators could use if they recovered DNA. And yet, he did all of these things anyway. There are several possible explanations. 1. He believed he was smarter than the investigators. Arrogance is a common trait among offenders who commit planned, methodical crimes. They believe they have accounted for every variable, anticipated every investigative technique, outsmarted the system. This belief persists even in the face of evidence that most offenders, even sophisticated ones, are eventually caught. 2. He underestimated the speed and scope of modern investigative technology. Academic knowledge of forensic techniques is not the same as operational understanding of how those techniques are deployed in real time by well-resourced law enforcement agencies with federal support. Kohberger may have understood, in theory, that license plate readers and cell tower data existed. He may not have fully appreciated the density of that surveillance infrastructure or the speed with which it could be analyzed. 3. He believed the crime would not be attributed to him because he had no prior connection to the victims. Stranger homicides are statistically harder to solve than homicides involving known relationships. Kohberger may have believed that without a documented motive or prior contact, investigators would have no reason to focus on him even if they recovered evidence from the scene. 4. He made emotional or psychological errors that overrode his intellectual understanding. Planning a crime and executing a crime are not the same thing. The psychological state required to commit 4 brutal murders is not the same as the calm, rational state required to execute a flawless forensic countermeasure plan. It is possible that Kohberger planned more carefully than he executed, and that in the chaos and adrenaline of the actual event, he made mistakes he would not have made in a calmer, more controlled state. Whatever the explanation, the result is the same. He failed, and those failures are now the foundation of the prosecution's case. As of this analysis, Bryan Kohberger has not yet gone to trial. The case remains in the pre-trial phase, with both prosecution and defense filing motions, challenging evidence, and preparing their respective strategies. The prosecution's case will rest on the evidence I have outlined: the DNA evidence linking Kohberger to the knife sheath found at the scene, the cell tower location data establishing his presence in the area on multiple occasions before the murders, and the suspicious gap during the murder window, the vehicle surveillance footage, the eyewitness description from the surviving roommate, and the physical and digital evidence recovered during the execution of search warrants. The defense's strategy will likely focus on challenging the reliability and legal admissibility of each piece of evidence. They have already mounted a constitutional challenge to the DNA evidence, which was denied but could be raised again on appeal. They will likely challenge the weight of the touch DNA evidence, arguing that secondary transfer or contamination could explain Kohberger's DNA being on the sheath without him being the perpetrator. They will challenge the reliability of the eyewitness identification, pointing to the 8-hour delay and the traumatic circumstances under which the witness observed the individual. They will argue that the cell tower data, while showing Kohberger's phone in the area, does not prove he committed the murders. Whether that strategy will succeed depends on the jury. Circumstantial evidence cases are won and lost on the jury's willingness to connect the dots, to see the pattern that emerges when multiple independent pieces of evidence are considered together. The prosecution will argue that the pattern is clear, consistent, and overwhelming. The defense will argue that the pattern is speculative, that each piece of evidence has an alternative explanation, and that the prosecution has not met its burden of proof. That is the trial ahead. There is a version of this story where Bryan Kohberger walks free. It is the version where he does not leave the knife sheath, where he does not drive to the crime scene on streets covered by cameras, where he leaves his phone at home during the reconnaissance visits and the night of the murders, where he does not return to the scene hours later, where he understands fully and operationally the density of the surveillance infrastructure he is moving through and takes effective countermeasures. It is the version where the DNA evidence is excluded on Fourth Amendment grounds, where the cell tower data is insufficient to establish presence, where the eyewitness account is discredited, where the vehicle footage is too ambiguous to support identification. That version exists. It is not hypothetical. Every piece of evidence in this case was contingent. The DNA evidence nearly was not admitted. The cell tower data could have been less complete, The surveillance footage could have been less clear. The investigative genetic genealogy could have been ruled unconstitutional. Bryan Kohberger came close to that version, closer than most people realize. But he did not reach it. And the reason he did not reach it is because he made 17 specific, documentable mistakes, each individually survivable, collectively fatal. This case is not a story of inevitable justice. It is a story of forensic science, investigative persistence, legal contestation, and an offender who believed he was smarter than the system, but was not. 4 people are dead. Kaylee Goncalves, Madison Mogen, Zana Kernodle, Ethan Chapin. Their families are left with grief that will never fully heal. Their friends carry the trauma of loss. Their community has been forever changed. And the person accused of taking their lives is facing accountability because of evidence he left behind. Evidence he generated. Evidence he could have avoided. That is the story of Bryan Kohberger and the DNA evidence that nearly wasn't admitted.